Hello, everybody. Welcome to the election law panel at the 2021 AALS meeting. I'm Gene Mazo. I'm the chair of the section on election law this year. The topic of our panel is called Voting During a Pandemic, Lessons from 2020. On today's panel, we have a bunch of distinguished scholars in our field, Bertrall Ross, Justin Levitt, Lisa Marshall Manheim, Michael Morley, and Ned Foley. Thanks all of you for being here. As you've probably seen from lots of my emails, we've tried to do something new this year. We've tried to kind of rejuvenate the section on election law. And in addition to this panel, we're also going to have, we're going to give out a new achievement award. I'll say that, and join us tomorrow for our section networking session. We'll give that out. We have a new distinguished scholarship prize that we're going to give out in section, and some honorable mentions as well. We have a networking event tomorrow from 12:15 to 1:15. On Saturday, we have a works in progress conference where there are 12 papers and 28 or 30 commentators and presenters. Everybody's welcome to come to that. Just email me if you want the schedule or the links. And finally, we have a new section newsletter sent out to some of you last night, and lists all of our new publications and features and profiles of the new people in our field and some people that have been in our field for a while. So there's a lot going on. Okay, on to our panel for today. 2020 was a year like no other. And it was a year like no other from the standpoint of election law. We had two huge things happen. The pandemic, of course, which changed how we vote and so forth. I think back to the primary that happened, the Democratic primary between the six people that were around in the Iowa caucuses, and that seems like decades ago, given the pandemic. The other thing that happened is, we had a presidential election where one of the contestants has refused to concede. And I know this panel is happening at 11 o'clock, but in 2 hours, the Senate will meet and the House in a joint session to count the electoral votes. And some of the people on this panel probably have a screen that they're looking at, trying to figure out what's going to happen there as well. So we're going to talk about a lot of these topics. And we'll start with Bertrall. Everybody's going to present for about 5 minutes, and then we'll open it up to discussion. Let's start with Bertrall, who's going to talk to us about turnout in this pandemic election.
Thanks, Gene. It's great to be here with you all, even if only virtually. As many of you have, I have Georgia on my mind, so I will focus a bit on Georgia, but I'll relate it and connect it to the pandemic in particular without focusing too much on Senate results, as we may talk about that later in the panel on what went down in Georgia. Now, what Georgia did in terms of the presidential election was provide kind of a model of how to increase turnout during any election, and particularly a pandemic election. One thing that can get forgotten amidst all the noise that's going on around us with respect to this election is that it was a remarkably successful election, a successfully run election, a well-run election. The concerns that many of us had going into it about whether states would be able to pull this election off during a pandemic, switching to different means of voting midstream, those doubts proved to be mostly unfounded. And we saw that as compared to the primary elections in April of post-pandemic, which had some chaos associated with them, that were not as successful as the elections to come, the election administrators were able to manage an election in a very effective way. And so that managing of elections and the way that they operated elections in many states was to open up different channels for people to vote. And these different channels for people to vote included adding means to vote absentee via mail, even without excuses in states that never had no excuse absentee balloting, or absentee balloting to the extent that they had during the pandemic. It was also opening and making available early voting in person in ways that we had not seen, or to the extent we had not seen in prior elections. And of course, we had election day voting. And so what this election demonstrated to me, given that we saw turnout bump up to around 65 to 70%, 67% or so, is that if you open up the channels by which people vote, then you're probably going to get more people to vote. Now, I understand that this was a high intensity election. People were intensely interested in it, but we also had a countervailing factor of a pandemic that made it harder to vote. So if you kind of put those two things together, it suggests that something went right to increase turnout by that much. And as comparison, as a contextual point, in the 2008 election, which is always praised as a relatively high turnout election, we had turnout around 60, 61%. So this is a substantial bump from a high turnout election. And it shows that in the United States, we can achieve higher turnout elections. But I do not want to focus just on the means of voting, because I think another thing that this election proved, and I think Georgia provides a model for, is that if you organize and if you mobilize and if you focus your mobilization activities on infrequent voters and low propensity voters, you can increase turnout amongst groups that have not voted in prior elections. And so I think that the lesson from Georgia, and particularly organizations like the New Georgia Project, Voto Latino, Black Voters Matter, Fair Fight, is that if you focus your energies on mobilizing low propensity voters, you can get them to vote. And so that provides a lesson for the rest of the United States. I'm a person who's written about how to get low propensity voters to vote and focusing on mobilization activities as the means, that if we could sort of extend these means nationally, we can achieve higher turnout elections for the future. Do I believe there'll be full turnout elections in the future? I don't think so, but I think that we can have elections in which there's much less of a gap between the rich and the poor in turnout. In past elections, we've had about a 30% gap in the rich and the poor in turnout. If we can reduce that gap dramatically, and I think that that would have a corresponding effect on how our political system runs and what policies are pursued. Because to the extent that you have low propensity, low income voters voting, then there probably will be greater attention to the needs of these particular voters, which I think would have a correspondingly positive effect on reducing economic inequality, which is one of the difficult challenges in our current day. So I will leave it there and turn it over to the next speaker. And I look forward to the conversation to follow.
Michael, you're next, I think.
Great, thank you very much. So building on what Birchall was talking about, I think that this past election provides us insight into the diverse range of ways in which states respond to election emergencies. In some states, we actually had a statutory framework in place that granted state officials, in particular the Secretary of State, or in some cases county officials, discretion to adjust or suspend or modify particular rules governing their electoral process in response to unexpected disasters, such as COVID in this cycle. In other states, we saw secretaries of state use their authority as chief election officers to interpret election laws or to promulgate emergency regulations within the scope of their powers under the election code, to adopt new interpretations, to perhaps push the bounds of statutes in order to have them apply effectively to new and unexpected circumstances. In still other states that lacked election emergency laws and in which secretaries of state didn't promulgate emergency interpretations or emergency regulations, we saw the governors themselves step in. Because at one point, I don't know if it's still the case, every state in the nation was under a declared state of emergency due to COVID. Many states have statutes allowing governors during declared states of emergency to issue executive orders that suspend state statutory requirements, suspend state deadlines. And so we saw governors in many states exercising their authority to issue executive orders to, in a sense, modify the election code on the fly as it applies to this election in order to respond to the unique threats posed by COVID. As we might recall from the primaries, however, right, not every state allows this. And so in states where the governor lacked this authority and yet attempted to exercise it anyway, the state Supreme Court would step in to prevent that. For states where either the governor or election officials did not on their own take steps to address the pandemic, or in the view of some active groups didn't go far enough in addressing the pandemic. The other main avenue for response was, of course, litigation. And both during the primaries as well as during the general election, we saw literally hundreds of state and federal cases throughout the nation seeking emergency relief in the form of temporary restraining orders, preliminary injunctions to either modify or suspend particular rules concerning the electoral process, to extend the time period for voting. The Supreme Court, of course, early on in its ruling in RNC versus DNC, issued two framework principles that went on to play a substantial role in later litigation. First, emphasizing that the Purcell principle applies in the context of election emergencies, which I think is an erroneous conclusion, but then also creating a remedial hierarchy, stressing that a court should attempt to use election modifications, tweaking or modifying or suspending rules governing the electoral process where necessary to respond to election emergencies, rather than what I call election postponements, which is either extending or changing or putting off the period for voting to include deadlines for returning ballots. One of the intriguing questions that arose as a result of the widespread modifications that COVID triggered, both, again, from local officials, state officials, courts, is the extent to which the Equal Protection Clause places outer bounds on permissible disparities between counties or disparities between opportunities to vote among voters participating in the same statewide elections. Right, it is commonplace that certainly different state election codes differ from each other, and precisely because a presidential election is run as a series of 51 independent elections for different slates of electors in the states and the District of Columbia, disparities between states are commonplace in terms of how you can vote, when you can vote, security restrictions on the voting process. But one of the issues that was repeatedly raised over the course of this election is, to the extent that different counties either adopt different policies, adopt different interpretations, does this start to push up against the holdings of Bush v. Gore? To what extent does the Equal Protection Clause limit a state's ability to respond to emergencies selectively or to delegate authority downward to county and local officials to respond to election emergencies in a way that might result in different voters in different parts of the state having substantially different opportunities to either cast ballots or to have their ballots be counted? And certainly, right, as we move forward to the aftermath of this election and to future elections, I expect this is an issue that at some point the court will be forced to revisit.
Thanks very much, Mike. That was very interesting. Rebecca, you were going to talk a little bit to us about the crisis in voter confidence and transparency that we saw in this election, or what is happening in that realm.
Great. Yes, thank you. Thank you for inviting me to be on this panel. So one important narrative about November's election, and one that Burchell just discussed, is that America dodged a bullet. He noted that there was quite a lot of concern prior to the election about massive disruptions, such as violence at the polls, potential cyber attacks, lack of poll workers, not to mention, of course, challenges associated with conducting an election during a pandemic. None of this transpired. We all breathed a sigh of relief. But as we find ourselves on the cusp of the election's conclusion, at least here's hoping, it has become clear that we did not, in fact, dodge a bullet. Instead, as I've said elsewhere, I think we took a direct hit. It came in the form of critical injuries to public confidence in US elections. According to polling, since the election, trust has plummeted acutely, especially among Republicans. Prior to the 2020 election, 66% of GOP voters said they had at least some trust in the US election system, and that amount dropped to roughly 30%. Exit polling last night in Georgia revealed that only 2 out of 10 Republicans thought the presidential election was conducted fairly. So to some commonly cries foul, but 2020 puts that concept on steroids, egged on no doubt by Trump's refusal to concede and consistent false statements about fraud after the 2016 election, right up through the 2020 election and since. One of the clear questions election administrators face, and really anyone who cares about democratic functioning faces, is how to restore public confidence in election outcomes. Because if we can't figure this out, then democracy is tough to pull off. Transparency is one way to help restore confidence, and looking at transparency statutes in the states, I think there are multiple problems that 2020 laid bare, and I thought I'd just very briefly focus on three. First is the lack of uniformity between states. And I think that sowed confusion and mistrust. For example, state rules for who can observe and how observation works vary widely. And especially in voting environments where you have many people campaigning in places other than their home states, confusion about observation breeds mistrust. This might be a good place for federal legislation to increase uniformity. Let me be clear that I'm not suggesting a system of federal observers. Instead, the process could be intensely localized, but I think greater uniformity would be helpful in this space. Second, state election transparency laws are underdeveloped and often stale. The most glaring example of this year is that many state laws governing election transparency are holdovers from the days when most voting happened on election day at polling places. This is, of course, no longer the case. Even before voters cast ballots in a pandemic this year, mail and early voting rates have taken off, and transparency statutes simply don't reflect that reality. Third, and finally, states haven't mastered ways to leverage technology to promote public confidence. The Trump campaign before the election filed suit in Pennsylvania seeking access to observe at early voting sites, and a court denied this request. But it seems to me that there was at least a potential for getting to yes in that dispute using technology to enable oversight by anyone interested. I think it's important to mention that, or to point out that transparency is no panacea for restoring public faith in US elections. Very importantly, transparency can sometimes feed public distrust of elections. This year, for example, conspiracy theorists exploited video feeds of innocent election work to forward claims of malfeasance. But that makes the work of getting transparency right even more important. And I think many things on many fronts must be done to restore public confidence in election outcomes in this country. But in my mind, getting election transparency right should be very high on that list.
Thanks so much, Rebecca. That was such an interesting presentation. We're going to move on to Justin. I want to say before you go, Justin, I tried to follow your litigation tracker, but the cases just increased at such a fast rate. And at some point in October, I published something using your statistics saying that there were 275 lawsuits filed. And a week later, I checked it, and the number just, was just kind of rising. So all of this is just to say, welcome to hear what you're going to say about pre and post election litigation.
Well, thanks, Gene, and thanks to AALS in this section, and thanks to all my fellow panelists. Yeah, if anything, that's a lesson for law professors out there, is be very careful what you decide to take on. I was curious about the pre-election litigation, and so started following, and then I thought, well, I might as well make this available to everybody, and then all of a sudden there were 300 and some election law cases. So I too want to I want to agree with virtually everything that's been said, and put a slightly different asterisk. We had a remarkably smooth election, a remarkably fulsome election, given our exceptionally low standards. Given the pandemic, given the floor level bar that we set for ourselves, we jumped way over it, which is great. It is possible, I think, to celebrate the heroic, and I really do mean that word, heroic efforts of election administrators and of voters in coming out as fully as they did and being as engaged as they were during these pandemic times, and still also recognize that 70% turnout means 30% sat home in this election. In these high stakes election, 70 to 80 million eligible Americans didn't participate. And that asterisk, I think, is still a big asterisk that we need to contend with. There's something wrong when that many people decide to sit out. As Michael said earlier, the pandemic provided other changes in our election infrastructure as well. It caused people to turn to state legislatures and turn to state executives to try and adjust circumstances to the completely changed environment in which we found ourselves. And when that didn't work, either because officials wouldn't or couldn't, under their own state law, change quickly enough, people turned to the courts. I want to talk just a little bit about what the courts did in this election, some of those 300 and some election cases before the election and after the election. Before the election, I want to make clear, I did not always agree with the court's assessments of the facts in play before them or their legal conclusions. There were some cases I agreed with, some I really strongly disagreed with. Some courts granted relief that was requested, some didn't, some granted some and withheld others. But across the board, I think it's fair to say, no matter the judge, no matter the system, no matter state or federal, courts acted like courts. They demanded real evidence of harm, both from people who were trying to upset the laws that had been in place and people who were trying to change the laws that had been newly put in place. They did not merely accept hand waving and all caps exclamation points as evidence. And they paid attention to precedent. They had, as Sam Zakharov reminded us just the other day, they had a strong status quo bias. That's what courts do, but they acted like courts. Trial courts, particularly, I thought performed very well before the election, both state and federal. Federal courts of appeal, including SCOTUS, did a little less well on my assessment. And my critique isn't generally on the substance of their rulings. The substance was generally, by and large, well within normal margins. There's, I think, one truly renegade substantive decision out of the Eighth Circuit I'd hold well apart from all of that. But outside of that opinion, the federal courts of appeal on the substance generally weighed in ways that we expect courts to weigh in. Where I was really disappointed was on the procedure, on stay orders, on the particular growth of the shadow docket. Michael mentioned the Purcell principle. I'm not sure what that is anymore, because all we got in the pre-election period were repeated presses of the pause button without explanation by courts of appeal that were overlooking the very careful work that trial courts did on the fly, with real attention to evidence, with real attention to circumstances, to respond to a shifting world in very narrowly tailored ways. And the courts of appeals essentially just said no, without explanation. And in my mind, led by the Supreme Court, by the way, they were following a lead that I thought was wildly improper, that what we saw out of the shadow docket, out of the stay procedure, was less law and more power. So the trial courts, I think, performed admirably given the extraordinary circumstances they were put under. The courts of appeal, where they got to the substance, I think did the same. But the shadow docket really concerns me. Post-election, I think it's even more emphatic to say the courts have acted like courts across the political spectrum. There was, I think, from relatively less informed observers, wide expectations that courts would simply vote according to the party of the president that appointed them, or their own political party where they run for office. That didn't happen. And I think that was not a surprise for most of us that watch the courts for a living. But it was gratifying to see that judges were acting like judges, requiring real evidence, requiring real legal claims of harm. What the courts refused to do, and this is where I'll close, is perhaps just as important. They refused to act purely based on partisanship. Judges, even when they're elected, aren't Republicans first and judges second, or Democrats first and judges second. They're judges first. And they acted that way. Where they're appointed by a president, the same thing holds. Doesn't matter who appointed them. The judges have acted like judges. They have different orientations and different perspectives on what the law required, but they were not merely political actors throughout the course of this extraordinarily polarized political year. They didn't take up ridiculous cases. There were some cases that were built solely on flat earth conspiracy theories and really nothing more. And the courts didn't take them up. And I think that's just as important in refusing to resolve them as in weighing in at all. Courts aren't rescuers. They deal with facts that are put before them, with legal claims that are put before them. And the courts didn't generally say, I alone can fix this, even when there were multiple litigants, particularly in the post-election period, asking them to. I think that too is admirable and also not a surprise, but something we ought to highlight and praise. A third thing the courts refused to do is to issue dispositive truth. And here I think this is a little bit of a sociological failing. This is us putting too much on the courts. There were a lot of entreaties, both by some on the conspiracy fringe and by a lot of others, that wanted the courts to affirmatively weigh in and tell us definitively what happened, the truth of the election process. But that's not what courts do. Courts weigh in on particular legal claims given the facts presented to them. They're not authoritative truth-finding bodies, except to the extent that the evidentiary process puts that truth before them. So I'm glad that we didn't have free-roving boards of inquiry that put a definitive stamp on what truth is when the conditions weren't there to present them with the evidence to accomplish that task. And the final thing, and here I'll leave, and this is more of a surprise about what courts haven't done. Courts haven't yet really policed their docket management function to sanction some of the more outrageous, less fact-bound, more frivolous conduct out there. There has been opportunity. There will, I think, continue to be opportunity for courts to really inform lawyers when they're behaving badly. And I would hope that some of the worst behavior by some of the litigants in the post-election period, the courts would actually maintain the integrity of their own courtrooms by reprimanding. There's a wide spectrum of reprimands possible. Some of the conduct we've seen in the post-election period here, I think, deserves some of the more weighty sanctions that a court can impose.
Thanks so much, Justin. If the courts did well, and that's great to hear, for fraud narrative in the rest of society didn't go as well. So Lisa, you were going to say a few things about that.
Yeah, thank you. And thanks so much, Jean, for putting together this panel and for all your work at AALS this year. So I was hoping to talk just a bit about disinformation and a few implications that disinformation has for election law right now. And the punchline, of course, is that we have a big disinformation problem. So I'm going to focus in particular on voter fraud. So first, if I could start with just like 30 seconds of historical background. For decades, what we've seen is politically motivated actors waging, in a sense, a propaganda campaign regarding the threat of voter fraud. And this campaign has largely been successful. It's persuaded many legislators, as well as many in the public, that the threat of rampant voter fraud demands suppressive voting restrictions. In the last few years, the pretextual nature of many of these concerns has really become clear. And this is not only due to the clumsiness of someone like President Trump in talking about the issue, but also due to the candor that we've seen from far more reliable and truthful Republican establishment figures. But also during these last few years, this voter fraud narrative, in a sense, has mutated and transformed into something else. And that's because no longer is the dominant narrative in this context about the threat of voter fraud. It has moved into the idea that there is actual voter fraud. And this distinction, in my mind, between the threat of voter fraud on the one hand and actual voter fraud on the other hand, the latter is far more problematic from an election law perspective. And one way of thinking about this is that this sort of mutation in the disinformation campaign, this mutation puts pressure on individuals, it puts pressure on institutions, and it puts pressure on the system as a whole. So first, in terms of the pressure on individuals, now, these are serious crimes being alleged. So of course, when it comes to individual voters, there's going to be concerns about the threat of prosecution. There's concerns about the threat of intimidation by people who are buying into this narrative. But what's more, what's being alleged at this point is so outrageous, so inflammatory, that it also pulls in election officials in a way that affects those people as individuals. Election officials are dealing with a flood of unwarranted criticism. And even beyond that, they are experiencing intimidation, harassment, threats of violence, all coming out of the November 3rd election. This is unfortunately against the backdrop of election officials already in many places feeling burnt out, feeling like there's an overwhelming amount of work and there's not enough support. To add on top of that, these threats of frankly, even violence at times, really puts a pressure on them as individuals that I don't think can be sustained. So second, in terms of the pressure on institutions, when you have this narrative of widespread voter fraud being promoted, you're going to just get a massive amount of challenges. There's not really a limit to the number of challenges there's going to be to an election outcome. And that's something that we're also seeing. And this sort of pressure is being put on institutions now. On the side of the institutions that are charged with administrating elections and counting ballots, you see a massive amount of pressure on those institutions where I agree with Rebecca, transparency is really important, absolutely. It is unfortunately the case that some of what people are doing with this information is not actually looking for problems, but instead looking, which is generally a good thing, but instead looking in a sense for materials to be used as part of disinformation campaigns. So that's a pressure that's being put on institutions that I think is tagged to this kind of evolving narrative. The courts, of course, are also grappling with this phenomenon. They're dealing with all of these post-election lawsuits. As Justin points out, the courts are able to handle this pretty well, actually. They're used to, frankly, frivolous, baseless lawsuits, so they can figure out what to do with those. That being said, the amount of challenges we're seeing is so high that again is putting pressure on the judicial system that's really problematic. And to that end, I would just remind everybody that while the most high-profile lawsuits involve the presidential election, this is going down ballot as well. So we're seeing in a half dozen states, we're seeing baseless election challenges that are still going. In Washington State, we just had a lawsuit filed last week, for example, by the Republican candidate for governor who lost by double-digit percentage points in the November election. And then finally, on top of the pressure on individuals, the pressure on institutions, this puts massive pressure on the system as a whole. It's playing with fire to promote fictions associated with even the threat of voter fraud. But when you move and start trying to convince people that actual voter fraud has taken place, it's really logically impossible to reconcile that with the belief that the system is working. If you truly believe that the 2020 presidential election was decided on the basis of fraud, it's really hard to reconcile that with buy-in into the system going forward. The system has failed, if you believe that. So this, of course, potentially translates into a lack of legitimacy, which in turn threatens any number of, parade of horribles. And again, this circles back to some of the things that Rebecca said, including about the number of Republicans who think that the presidential election was conducted in a fair manner. So none of this is good. This is all very problematic. But I guess what I would say is that in my mind, recognizing the phenomenon is really important. And as election law lawyers, one thing that we can do is to look to how the law may be able to respond to this. On the one hand, by helping to protect and support individuals, individual voters, individual election officials. And on the other hand, how we might try to structure some of our institutions and have them respond to these problems in a way that makes them more resilient in the disinformation environment that we're facing.
Thanks so much, Lisa. That was very interesting. We're going to move on to Ned next. I just want to say a little side point. Ned is one of our country's foremost experts on contested elections and on the Electoral College. And a few months ago, when I sent out the invitation to appear on this panel, Ned asked me, what time's the panel? And I said, well, it's January 6th from 11 to 12:15. And I think Ned wrote something back to me like, Gene, do you know what happens at 1 o'clock? Of course I knew, but I just thought it was a non-event. And he replied saying, well, that's just a non-event. Who pays attention to that? Of course, Ned has had his eye on this event for a long time. And it's become an event. An event has become an event. Anyway, I don't want to take up Ned's time, but I just wanted to mention that little back and forth that we had. Now it's sort of, I'm remembering it again. All right, Ned.
Thanks, Gene. I hope that means something's auspicious as opposed to inauspicious. But frankly, I've been mesmerized. I think this has been a great panel. Everybody's comments so far have been really thought-provoking. I've been sort of mentally revising my own remarks in light of all the great points that all of you have been making. So I just hope I can build on some of what has been said previously, and picking up maybe most directly from where Lisa left off, and maybe provocatively sharpening her point. I think we are in this new period, which I've started to label electoral McCarthyism, because I think we see the qualities of the pathologies that afflicted the McCarthyism period during the Red Scare applied to the first time to the electoral process in a way that I am unaware of in prior American history. And I thought Lisa did a really helpful job talking about how there's something new going on now that is a continuation or an exacerbation of the voting wars that we have been seeing over the last decade or so. And we have to kind of diagnose this before we can cure it. And I agree. I guess I appreciate in what Lisa was saying that there's more of a continuity than I was about to say in opening my remarks. I was going to start by talking about how Rick Hasson, for our field, had helpfully, framed the term the voting wars, which sort of exploded after Bush versus Gore. And they may have gotten worse or intensified, but I thought they had a certain character, which was marked by political polarization, intense partisanship, some of the fight over voter ID laws, for example, in that context, but also the acute gerrymandering that occurred and has occurred in the last 2 decades of redistricting. Those qualities to our electoral system, are problematic. And they certainly, the period from 2000 prior to 2020, again, had a certain character of the voting wars, but they were not unique in terms of American history. You go back to the 19th century, gerrymandering's been around forever. It gets periods of intensification. The kind of fighting that we were doing over voter ID in the last decade or so, we were doing over voter registration back in the 1880s and 1890s. And there was litigation over that, not just fighting in the legislative process. So there is a new pathology that has emerged. I think there's no doubt that it's connected to the demagoguery of Donald Trump. A demagogue is an individual who has a charismatic relationship to his base, and that exerts a pathology on the political system. And that was true of McCarthy. He didn't apply his demagoguery with respect to counting votes. He applied it with his claims, false claims, that there were communists in the State Department or communists in the army. I have a list of 20 communists, never produced the list. When I saw Rudy Giuliani talk about, we have the evidence we're going to present, that seemed like Joe McCarthy to me, and never to be produced. But President Eisenhower, Senator Robert Taft, so-called Mr. Republican of the 1950s, they hated Joe McCarthy. They hated the pathology of what he was doing to their own party. But it took over 4 years to bring him down. And it wasn't, Eisenhower, even as president, couldn't bring him down. Taft, as majority leader, couldn't bring him down. You had the "have you no decency, sir" moment during the hearings where McCarthy almost brought himself down, but somebody, he was punctured by various people. Various people attempted to bring him down along the way, but it took 4 years. We've had our Gabe Sperling from Georgia try to bring down the Trumpian version of electoral McCarthyism, but Trump keeps on going. He hasn't been brought down. And that, I think, transitions into the point I want to make. He's going to leave office on January 20th, but he's talking about running again. Frankly, his conduct, particularly that phone call to Raffensperger, over the weekend, but even his entire body of conduct since November 3rd, should disqualify him from seeking future office. I was not a fan of impeachment. I believed, as did Senator Lamar Alexander, that the American people should deliver the verdict on whether the Ukraine phone call was inappropriate and deliver the verdict in the ballot box. But the implication of that was that the American people's verdict had to prevail. And of course, what does Trump do but simply want to repudiate the verdict of the people? And if it was just Trump, that would not be a pathology on our system. It's the fact that you've got significant members of his own party in Congress on the House side and now on the Senate side, at least to some degree, willing to go along with the McCarthyism. So how do we overcome this pathology? It's a challenge for the country and it's a challenge for the party. I frankly think that the highest priority for the Democratic Party in America is to heal the Republican Party, or to help the Republican Party heal itself. America can't work without a healthy two-party system where both parties play by the rules, believe in the rules, play fair, and have robust competition. And so how do we get to that point? It's easy enough to say, physician, heal thyself, Republican Party, heal thyself. If they can't do it, what happens? So what should happen right now, I think, is the Republican Party should, make it absolutely clear that they disown Trump. He's persona non grata within the party. He will not be their nominee in 2024 because of what he's done in the aftermath of November 3rd. But in the aftermath of November 3rd, there are people lining up to support him in his reelection bid, and only saying that they're going to step into his shoes if he decides personally he doesn't want to run. But he is still the leader of that party, unless there is now a fight. We've started to see some talk, and maybe today and this afternoon will help play this out. Maybe are there two Republican parties right now, the party of Trump and the party of McConnell? A lot of Democrats have not been fans of Mitch McConnell, over Merrick Garland and everything else. But as between the party of Trump and the party of McConnell, I know where I would plant my flag. And I'm not a member of the Republican Party, but I think the Democratic Party needs a responsible Republican Party. And so I think, it's important for nonpartisan election law scholarship to point out when you have a Senator Tom Cotton want to play by the rules, or you have a Representative Liz Cheney talk about playing by the rules. I mean, this is a really important moment in American history, as I think we all know. And we don't know how the story is going to end itself, and if the party will heal itself. So let me just say a couple of quick things, to wrap up, and then I really look forward to the conversation. One is, almost every conversation about why Republicans do what they do is a fear of a primary fight. Well, if that's true, can we get some legislation that solves the primary problem? Why can't we get moderate Republicans and Democrats in Congress to adopt either ranked choice voting or the version of the top two primary system that California has, or some other thing, but to say, look, if the problem is that primaries force Republicans who would prefer not to be Trumpian to be Trumpian, then let's get the structural reform that takes away that incentive. Now, I can imagine the Democratic Party thinking this happened at the time of the Tea Party movement. There were a lot of Democrats who thought, well, let the Tea Party, really cause havoc within the Republican Party, because it's so much easier to run against a Tea Party crazy than a sensible, moderate, Republican. And in fact, the Democrats won some significant Senate seats because, the Republican Party kind of went off the reservation with their Tea Party candidates and couldn't win the general election. And, from a partisan short-term perspective of the Democratic Party, that gets them more seats. That's their advantage. But, the Tea Party was one thing. Trumpian, electoral McCarthyism is a new level of this pathology. And I would hope that Democrats in Congress would say, let's act some reforms that are in the general interest of the system as a whole, not in the narrow interest of the Democratic Party over the next 4 years or next decade. I don't want to pretend to have the exact prescription, but I think this dialogue and inquiry should be done from the perspective of the national interest as a whole, and that it is in the national interest to save the Republican Party from itself, or some version of it from itself. And then, and finally, I think that this leads, and this brings me all the way back to where Birchall started our conversation, with the success that comes out of Georgia overnight, and the point that turnout matters and mobilization matters. There is a big push on the left, and which I understand and to some extent agree with and are sympathetic to say we desperately need voting law reforms that that gets rid of Shelby County that gets rid of restrictive voter ID, and that implements the Democratic Party's vision of what good election law would be. And maybe that filibuster rule in the Senate's an obstacle. Can we get rid of it? Can we get Joe Manchin on board? I don't think at the moment, and I'm interested what other people have to say, I don't think at the moment that that's the right way to think about this, a pivot point in American history. Instead, and this is to Rebecca's point, if you have a significant portion of the Republican Party voters who now don't trust the system because of what Trump has done and what McCarthyism has done, the essential priority is getting that trust back. And getting that trust back isn't necessarily the most left progressive Democratic Party version of how to run elections. What Georgia proved to me, and tell me if I'm wrong, that Republicans, if they're reasonable, like Brad Raffensperger and Gabe Sperling, can actually run a fair election that doesn't have undue amounts of voter suppression and that doesn't cause inappropriate disenfranchisement. It may not be a perfect system. It may not be the ideal system from my own policy preferences, but as long as it's good enough, we have to balance that good enough value into bringing back trust. And this is where I think maybe I disagree a little bit with Justin. I mean, I worry about low turnout, but I'm less worried about the 30% who voluntarily didn't turn out if it was genuinely voluntary. I think the higher priority is to get that trust level that Rebecca is identified, back into a realm of normality. And one way to do that is to put in place a set of rules that both parties can buy into and that the voters of both parties can buy into. And that means maybe a voter ID law that, again, isn't unduly suppressive, but tries to meet Republicans in the middle ground. Now we can't buy into conspiracy theory. We can't have election law be the Trumpian version of election law. But a successful set of election laws for America for the next decade is going to be an election law that has elements of what Joe Biden's party wants and elements of what Mitch McConnell's party wants. And that's where Congress should be having a debate. If it's only Joe Biden's vision of election law and an attempt to say, Mitch McConnell, you're not invited to our party, we're writing the rules of election law without you because we don't like your rules, that's going to intensify distrust going forward. And it's not going to bring back those Republican voters' confidence in the system. So I hope we meet the moment and the challenge of the moment. I'm afraid that we might not. Thanks.
Thanks to all of you for your presentations. Look, this platform's a little weird, but let's try to have a conversation as best as we can. There's so many interesting issues here. Let me start here because we're all law scholars and we pay attention to the courts. As I said in the beginning, there's just two themes here, right? There's the pandemic and then there's Mr. Trump. Justin said the courts did fairly well, or at least the lower courts did fairly well. I don't know if I agree or not. We had those early cases in Ohio and in Wisconsin where we were stopping the vote and not stopping the vote. But ultimately, this gets to the Supreme Court and to Purcell. And I hadn't given this as much thought as some of you have. And I read Nick Stephanopoulos' post on one of these blogs about the shadow docket and Purcell, and it really woke me up to what was happening. So how well have the courts dealt with A, the pandemic, and B, the voter fraud narrative that the president has placed? And if you think the lower courts have dealt with it well, what happens when we get to the Supreme Court? Maybe you want to go first, Justin, on this, or everybody jump in.
Well, so I feel like I've already given my assessment of how the courts have done this cycle. So I'll give it literally one sentence, and then I really want to hear what other people have in reaction to that. I think the courts have done quite well with respect to both assessing pandemic changes or the lack of pandemic changes, and with respect to demanding real evidence rather than buying into a voter fraud narrative. In 2006, the Missouri Supreme Court said, we can't just give in to the perception of voter fraud because then our law becomes subject to whoever has the most powerful marketing machine. And I think courts across the board have actually realized the wisdom of that approach. The Supreme Court stay shadow docket troubles me a lot more because it comes without explanation, and it comes without an acknowledgement that a temporary stay is in fact a determination for any given election. And so that really concerns me more, but I've already talked about that. So I really want to hear what other people have to say in reaction.
Let's especially go to Purcell because this is a problem, right? In the beginning, we had stays or overturn of stays, and they came down party lines. I mean, if you think about the Wisconsin Supreme Court, some of the Supreme Court decisions. Anybody else want to jump in on this?
I guess one thing that I would say to sort of track a little bit about what I was talking about before is that the federal courts have a track record overall, I would say, of accepting states' sort of evidentiarily unsupported allusions to fraud concerns. They have a track record of accepting those without much in the way of real sort of judicial analysis when the courts are considering among other things, the constitutionality of state measures, which is a long way of saying that, when we're talking about the threat of voter fraud and the implementation of restrictive measures purportedly in response to that fraud, what we have is we have a track record overall of the federal courts accepting that at face value, even if it seems pretty clear that it's pretextual. And I think that precedent was problematic at the time, and I think it's becoming increasingly problematic as we see where this narrative is going. If the courts had pushed back on that in a case like Crawford and had actually sort of required some evidence to be put up, then maybe we sort of wouldn't have gone down the path of this voter fraud narrative as far as we have. One question that I think the federal courts should ask themselves in light of that sort of out of control nature of this narrative is whether those older precedents should be reconsidered a bit. And you see that, as Justin points out, you have a distinction between the lower courts and the Supreme Court. So we have seen the lower courts actually subject some of those allegations to a little bit more scrutiny. And I think that's been really successful when they've done that. So I don't have high hopes that the Supreme Court, as it's currently constituted, will take those measures. But in light of what we've seen, I think that it really calls into question the wisdom of just accepting those sort of claims at face value.
Anyone else on the role of? We can move on to a different topic. Or on Purcell itself and how that's played out in this. Okay.
Well, I'll say before we move on, if nobody else has anything, and maybe this will lead into a different topic of the sort of legislation that we might hope for or see coming out of the current Congress, the new Congress. Federal legislation can, and in other arenas often does, drive equitable remedies. So the Supreme Court has said fairly often that the equitable nature of an Article III court is within Congress's power to shape. And there have been movements to limit or cabin or otherwise direct, I'll say, the exercise of stay authority before. I personally would hope that that's one thing that the new Congress, and I don't think this is a Democratic thing or a Republican thing, to Ned's point, I don't think this actually feeds any one party's vision of what the process should look like. I'll hope that a very small and non-exciting piece of any new congressional legislation around voting rights, right? The thing that only the people listening to this forum will actually pay any attention to and will get absolutely no resonance in the public, is at least a demand that appellate courts, particularly reviewing late but considered trial court injunctions, have some sort of heightened standard before they just press pause, effectively nullifying that decision for a coming election. And I would hope for a requirement of a reasoned decision accompanying any such order, staying a particular lower court injunction, rather than just stayed, period, and that being the only explanation of the process. I think that's within Congress's power. And as one of the really low-grade administrative fixes to some of the issues that we've seen in the cycle, I'd actually like to see federal legislation not removing the state power, but cabineting, directing, perhaps fostering a more enlightened, more reasoned use of that power in the future.
Okay.
That's not, by the way, section 1 of my congressional legislation, but it's in there somewhere around section 275.
Okay, just to shift a little bit, I do want to come back to Ned because he ended on a very interesting note, but just to go back to the pandemic, Michael, let me go to you just for a second, and everybody else chime in as well. So, you've written a lot about election emergencies, and we all have read what you've written about election emergencies. We've had kind of two election emergencies again. We've had the pandemic, and then we've had the sort of contested election. I guess you may not consider the second an election emergency, but can you just say a little bit about how well we've responded to this election emergency, or what recommendations? You've had papers or articles where you've had all kinds of recommendations about what to do about automatic absentee ballots versus sending out a card versus some states, Nevada, New Jersey, Vermont, California, just sent out a ballot to every single person in November. Have we responded well, not well? What else could we do? Can you just say a few things about this?
Sure. I mean, I think we've seen overall we had surprisingly good turnout, right? Despite the obstacles overall, right? The election went surprisingly smoothly, particularly given, right, what we had seen in the primaries, right? Having said that, right, from a purely legal perspective, I think that some states were much better situated to deal with the emergency and to make the necessary adjustments than others, right? I think from a 30,000-foot perspective, one of the biggest distinctions you saw were between states where there was at least some sort of state-created infrastructure in place, whether that was a pre-existing election emergency statute, whether that was right, emergency steps taken from the Secretary of State through regulations, through interpretations, right, even right, the governor stepping in, as opposed to a court having to come up with right, new rules on the fly, a court deciding right in TRO or preliminary injunction proceedings what to suspend, what to allow to remain in place. And I think that, broadly speaking, what we would much rather have a statutory framework in place where legislatures can deliberate on these issues ahead of time, right? Not in the heat of a particular election, decide not just what are the appropriate types of steps to empower people to take, but also what are some types of steps that we want to put off limits, right? Well, I've referred to this as election emergency red lines, right? What types of security measures do we not want to allow to be suspended, right? Even in the face of an emergency, or what types of adjustments do we think are inappropriate? And I think that, one of the risks certainly of relying on the courts to deal with this. And again, right, in some circumstances, there's no alternative. If the state itself is refusing to act, then right, you're putting courts in the position of having to consider these issues. But I think right, some of the risks are number one, right, you're having generalist judges, right, who might not be familiar with the intricacies of the election system, trying to decide these issues right quickly, right, in highly partisanly charged circumstances based on right, largely right, self-serving filings right from both sides trying to defend their preferred perspectives. But the other thing is most judges look at this as a binary, right, where they're either going to issue an injunction completely suspending certain requirements, or they're going to deny it. And I mean, one thing, particularly from the perspective of the federal equity power, one thing that I would have liked to have seen more of would be judges exercising their equitable discretion to grant injunctions imposing right, substitute requirements, right, rather than just simply completely suspending particular rules that the entire state electoral system had been premised on, had been built on. If you just yank those out of the Jenga tower without replacing them with anything, I think that you're offsetting the balance that the system is based on. And so again, to the extent that legislatures can address this in advance, they're in a much better position to come up with right substitutes, fallbacks, other approaches that, for the most part, we didn't really see from federal courts. And so I think that's the only thing where I'd push back a little bit on Justin, that I do think, right, independent of the ultimate fairness of the system, right, public perceptions of fairness, even though that's subject to partisan manipulation, even though perceptions might be unfair and inaccurate, I do think that there is an independent, important interest in the perception as well as the reality.
I would,
Anyone?
yeah, I would just add, I think if there's one lesson that we learned, hopefully, from this experience, it's that, concentrating the vote on election day is problematic. and multiplying the different kinds of ways people can make their voices heard is helpful in the context of an emergency. But I think, stressing what Michael said, in doing that with careful planning, the alternate methods of voting can be just as secure as election day voting. So I think that really is the task ahead.
Can I ask, what is the concern over security? Like, in all seriousness, is it, and this goes to, I would say, to Ned's point too. I mean, is it responding to factually based concerns about the elections, or is it pandering to people who think there are concerns that aren't actually there?
Yeah, so I think drop boxes are the perfect example, right? So, we have this concern about the U.S. Postal Service, and all of a sudden, state legislatures are considering, should we put drop boxes outside of grocery stores? Well, the answer, if you care about access, is 100%. Like, let's make it totally easy, right? But you get yourself in a lot of trouble in terms of voter confidence, particularly, among people who are skeptical of vote by mail, right? If you don't do it well. And if you put out drop boxes that look like, clothes hampers, it clearly has to be done well is the only point I'm trying to make. And I don't think that it's an either or situation. I don't think it's something that you can accomplish both access and integrity. But I just think, when you multiply the ways people can vote, you can't ignore, concerns about making sure that it has both the appearance of and the actual, security.
I just am going to point out that I realize I just spoke and I'll stop talking, but I mean, when you have a propaganda campaign that is responding to anything that's out there with allegations of fraud and sort of, kind of really frivolous arguments about security issues, to be honest, I'm not sure how you respond to that. I mean, we have drop boxes all over Washington state. There's no concerns here because we're not a battleground state. Actually, it's the same.
Yeah, but Washington state's, thought through drop boxes very carefully, and it's very ingrained into the culture. Here in Virginia, when the legislature proposed drop boxes, it was scary. And I think, why have the scary? Why not just do it well? And in sort of as planned a way as possible. I totally hear you about not buying into the fraud narrative unnecessarily, but I don't think it can be ignored.
Yeah, and what I would just say to that, I think, there were well-intentioned progressive groups on the left prior to the pandemic and during the pandemic that tried, again, Justin talked about this, who tried to use litigation to change the rules in ways that made Republicans, not just Donald Trump, nervous. So like ballot harvesting laws, even the term ballot harvesting is controversial. Obviously, Democrats don't talk about it that way. But, legislatures had put in place rules that limited the degree to which organizations could do ballot collection. Democratic Party groups and voting rights groups didn't like that, wanted to litigate away those restrictions. That made people on the right nervous. Now, Donald Trump exploited that inappropriately, but we probably wouldn't have gotten into the terrible, McCarthyism-like paranoia over the process if it hadn't been triggered, frankly. And that's my judgment. Likewise, one of the biggest mantras from the Republican side, as there was obviously the need to move to absentee voting, vote by mail in the pandemic. But the thing that the folks on the right they didn't want a ballot sent to everybody. It seems to me that and that wasn't done in a lot of states, and there was a lot of misinformation about that. But as we go forward and think about what's a sensible set of rules for vote by mail, that again doesn't cater unduly to unrealistic concerns, but I think Michael just said, and I agree, just like we care about the appearance of corruption in the campaign finance context, I think it was legitimate for Purcell to say, and for election law and for Crawford to say, and for election law to be built around the notion there needs to be an appearance of integrity as well as integrity itself. The left can't say we worry about appearance of corruption about money in politics, but you can't worry about appearance of corruption with respect to ballot integrity. That seems inconsistent. And so, again, it's a balance, right? And we can't tilt the balance unduly in a disenfranchising, restrictive way. But I think we should get rid of signature matching, which is a 18th century technology. Let's get everybody a unique numerical identifying number, and you put on your absentee ballot envelope your number, and that authenticates your ballot. We don't have to worry about signature matching. That ought to be a win-win for lots of reasons. I'm afraid that the polarization of our politics prevents the kinds of things that Rebecca's talking about, where we can actually have some win-win on both integrity and access. But we fight so much over the voting rules, we never get to reasonable compromise.
I guess I worry in terms of the point that Ned puts out about the constantly moving goalpost, because I think that this has never really been about integrity. It's about sort of means of voting that make it less likely that we're going to win elections. And it seems to me that only at the point in which the likelihood and advantage of winning elections shifts to the side of those who are promoting integrity will that line of integrity be promoted and supported. And so I don't know how we get out of this. I do worry the disinformation that Lisa puts out there. There's always going to be something. You can have a perfectly set up sort of Dropbox system, but there will always be some conspiracy that you could put out about that system that suggests it's prone to fraud. And so I don't know in terms of what that step is forward. What I feel is that over time, you sort of experiment with different methods of voting, and you have fraud allegations that are not only rejected in court, but pointed out as frivolous, and you sort of change public perception on the corruptive effect or threat to integrity of different methods of voting through these means. Can we get to the point where, or get close to the point where we can sort of balance that line between integrity and access? But I worry about too much pandering, as Lisa says, to the concerns about the perception of fraud will lead again to the movement of the goalposts to the points where we're going to have very inaccessible elections.
Well,
And back a little bit on that. I mean, I don't disagree with a lot of that. I think some of the ugliness that we've had over the last decade or two was absolutely for partisan purposes, including voter suppression purposes. I don't want to deny that or justify that. But I also think we have to be careful as we move forward, not to say that every single proposal on the Republican side is motivated purely for partisan purposes and without any validity in terms of an integrity perspective. Because if you do that, I think it's a conversation stopper. And I think honesty requires that some of the proposals on the left are put forward because it's good for the party. It's not absolutely essential to have avoid disenfranchisement. And so again, I think politics is so toxic at the moment. There's so much distrust that we've got to take baby steps to rebuild our functioning two-party system. And again, I think if you don't do that, you're not going to bring around the people that Rebecca's talking about. In other words, I agree we don't want to pander, and you have to draw the line somewhere. On the other hand, if the number one pathology that we're facing is the fact that we've got one of our two major parties basically not wanting to play the democracy game at all, and a significant portion of their own voters don't believe you can trust the voting process at all, we've got to, what's the solution to that? And I don't think it can be putting into place more rules that we like that are going to make them be more distrustful.
So let me take this a little further. So, and we're coming kind of back to Ned's presentation, which was interesting. We all understand, I'm of two minds here, right? On the one hand, the Trump voter fraud phenomenon is awful. Another story is it's just a blip, and our institutions actually worked pretty well. We're going to have a change of presidential administrations. But whether Trump long-term phenomenon or a blip, the polarization is a long-term phenomenon, and we all know that. And this is what all of the social science research says. So on that note, just let me throw it out there. I mean, just sort of a friendly amendment to what Ned was saying. What do we do about this going forward? We know it's a problem, but we don't really have great solutions. Does anybody want to what we do. And just to add to that, can anybody predict what issues we're going to see in the 2022 election cycle going forward? Anyone want to speak to those issues?
Well, I'll just say quickly, I mean, of course, I have no idea how to fix it, of course. But I think one way of articulating how I increasingly have been feeling about these issues is that, and this goes to your McCarthyism point, Ned, you don't get to set the terms of the debate if your terms rest on disinformation and falsehoods. You also don't get to have a platform and have sort of the people sort of neutrally support your platform if your platform is really truly based on voter suppression. And in the last few years, that is unquestionably what we've seen. I mean, the president has said it explicitly, and we are about to go into some sort of political theater where we have the leaders of the Republican Party supporting the president after he has done things, for example, like call the Georgia Secretary of State and essentially, I mean, you guys all know about this call. So again, in a two-party system, both sides get to set the terms of the debate, for sure. In a two-party system, both sides' platforms matter. And there are plenty of people on the Republican side who are not involved in disinformation, who do not actually believe in voter suppression. The trouble is that the party has largely been taken over by people who do believe in those two things. And I don't think we can let them set the terms of the debate. That's not a fair debate. It's not a compromise when one side thinks that we should have less voter access, and that's actually the goal. Show me the Democrat who wants there to be less integrity in an election. That's not the debate. The debate right now is less access, more integrity. But there's also, anyway, I'm kind of rambling, but I guess that's what I'm saying. I think it might be the point where we have to stop acting like this is really sort of the same thing on both sides. It's just not.
And piling on perhaps, so I don't disagree with a word that Lisa just said. I think part of the test is that the moves to either restrict access or cast doubt on the outcome only follow battleground states. These are not, and maybe, Ned, this is a way to think about things that are more helpful. Restrictions on access is not a Republican platform position. If you look at Utah, a very conservative, staunchly Republican state, in its methods of voting, looks an awful lot like a lot bluer, a lot more liberal and progressive states. And what that says to me is where there's not a perceived threat from the electorate against incumbents, right? Where the incumbents aren't worried about the voters, which is exactly backward, then officials strive to make it easier without compromising any of the integrity measures for voters to vote. It turns out that people like voting securely and reliably in convenient ways. And where there's not an electoral threat to the incumbents associated with that, the incumbents make it happen. The pathology that Lisa's correctly describing is you only get to protest about the rules where the rules might make it possible for a different set of voters to express a different set of preferences. And I don't know how you change the rules to accommodate that concern. That is, I don't know how you adjust the rules of the election to accommodate that concern. And this comes back to Georgia. Georgia has, I think, a lot of election practices that some people would find problems with, and a lot of election practices that some people would find really reliable. But I don't think Georgia is on anybody's list of most progressive election states. And if the center of the conspiracy world right now is Georgia, with its pre-existing election structure, I don't know how you accommodate those concerns. I really don't. That is, and I think Lisa made this point earlier, or Burchell made this point earlier as well, if the goalposts keep moving, you can't ever reach the goalposts. And the sort of disingenuous attack on the system we've seen now strikes me as having far more to do with the electorate than the rules of the process. I too don't know how to fix that, but I know that I'm not eager to bend or break the rules of the process to try and accommodate a constantly moving baseline for what the proper election rules should be. And I think that's the wrong answer. It's not, Ned, that you don't have an entirely valid point in saying there should be reasonable compromise somewhere. But I can look to Utah and find a lot of reasonable compromise, different from indulging whatever we think might stop the conspiracy theories, because there's it's a causation question, I guess. I don't think the rules are causing the polarization or the conspiracy theory. And so I don't want to bend or break the rules in an attempt to fix or try to fix the contestation, the polarization, or the conspiracy theory.
We're running out of time. Let me, can we all come back on tomorrow? We're going to have a networking workshop tomorrow. Not workshop, we're going to have just a networking session. There's no programming for it. We're just going to chat. We're going to give Richard Briffault the John Hart Ely Prize in Election Law. We're going to give Nick, Justin, Josh Sellers, and Aaron Scharf their prizes. So come tomorrow, chat. We'll continue this conversation.